The three of you have made protected disclosures regarding DHS and Border Patrol failures to obtain DNA from illegal immigrants at the southern border as required by the law. And based on your opening statements, the Biden-Harris administration has failed to comply with the DNA Fingerprint Act. Mr. Jones, I'd like to start with a threshold question. How do DNA profiles help DHS, CBP, and other law enforcement agencies protect our communities and at the same time secure our border?
Senator Johnson, the DNA profiles that are generated by the collection at the border allows law enforcement to then log those DNA profiles in the CODIS database. If there is a latent or a crime scene DNA sample that is in that database, then it gives law enforcement an actual lead or investigative track to be able to reopen or open a cold case. The majority of the cases in that database, 45 to 50%, are sexual assault and rape, followed closely by homicide. In our experience since 2020, we have seen very interesting and promising results that come from these DNA profiles being loaded. The oldest case that was reopened, sir, was from 1972, which was actually a sexual assault. So the value to law enforcement is immeasurable. It's in addition to fingerprints and photographs, and it gives our state, local, and tribal authorities the ability to follow up on cases. It gives victims and their families a level of closure, and it can also exonerate those that have been possibly wrongly accused.
If the Biden-Harris administration followed the law instead of flouting it, how would that have played a role in preventing the murder of Rachel Morin? For you, Mr. Jones.
Sir, as we look at the failures and successes, even at the 37% threshold that we're seeing today, in focusing on the case you referenced, we know that the subject was encountered by CBP and DHS at least 3 times. His DNA was never collected. On his 4th trip across the border, he's said to be a gotaway. He avoided DHS and CBP, Border Patrol, and was able to get into the United States. He ended up in California, and in March of last year, he was involved, according to law enforcement, in a home invasion and sexual assault of a mother and her 9-year-old child. In that encounter, law enforcement was able to collect DNA samples and sent them to CODIS. Unfortunately, there was no match because we did not collect his DNA as we should have. From March and until August, there was no investigative lead that would have led us to the subject. Do we know if we had that investigative lead and had identified the subject, we could have located him? Possibly. We know that there would have been an NCIC record placed into the federal law enforcement system that said if any state, local, or federal agency encountered this subject, he would have popped as a person of interest in the original home invasion and sexual assault of a mother and a child. He could have been apprehended. We could have had a person to look for. Do we know if we could have absolutely prevented Rachel Morin's rape and murder? We don't know that, sir, but we do know that if we were able to identify this subject earlier, he would have been on law enforcement's radar and potentially apprehended.
Also for you, the administration's DHS and CBP aren't collecting DNA at some locations at the southern border. Where, why, and what's the impact on our national security?
Sir, Senator, a colleague of ours was visiting sites along the southern border, and they went to approximately 12 sites, and neither Border Patrol nor Office of Field Operations were collecting DNA at any of those sites while they were present. They asked the officer and agents why they weren't doing it. And the response our person told us was, they're just not doing it. The impact is, again, we are allowing investigative leads to get past us, and we're frankly violating the very law that was passed by Congress in 2006 and implemented by the Department of Justice law enforcement entities in 2009. So the impact is clear.
Mr. Taylor, regarding the ongoing whistleblower court case with your colleagues, has the administration, DHS and CBP, made false or misleading statements internally or explained or public about it? If so, please explain.
Yes, Senator Grassley. When the Office of Special Counsel began investigating our allegations of whistleblower reprisal, this started back in 2018, I'm sorry, CBP told the Office of Special Counsel that we were poor performers and were about to be fired. When the OSC pointed out that we'd received significant awards and public recognition for our outstanding work 6 weeks before the dismantling of our group, CBP then stated that we weren't a good fit in our current organizational location. When the OSC told CBP that we were reprised against and should be restored to our previous position, CBP told the OSC that the funding was no longer available. When the OSC pointed out that CBP's recently submitted budget included expanding the number of personnel in our WMD division by 500% over the next 5 years, CBP said that that money was reappropriated. A seemingly innocuous email sent by me to CBP's Finance Center confirmed that the WMD funding was indeed available and currently being utilized elsewhere by CBP, as it is today. In fact, one of our salaries, as Mr. Jones had articulated earlier, has been paid out of the WMD budget for the last six plus years, proving our point that the Office of Special Counsel has been perpetually lied to by CBP. Numerous individuals in multiple offices in CBP have made known false statements to the OSC, the Merit Systems Protection Board. They've also made known false statements to congressional oversight groups. CBP's table of offenses clearly articulates that the penalty for knowingly making a false statement in an official inquiry is removal. There are no mitigating factors, and yet no one has been disciplined. On September 23rd, Senators, you are aware, you wrote to Secretary Mayorkas and Acting Commissioner Troy Miller about CBP making false statements to the press. Your staff had confirmed with the Office of Special Counsel twice that the Office of Special Counsel had sought corrective action on our behalf. CBP made public statements to the New York Post stating, quote, "The Office of Special Counsel terminated its investigation into these claims without issuing a prohibited personnel practice report or seeking corrective action." That is clearly a lie. Rather than issue a retraction, CBP stated that, quote, "This is a mischaracterization of this issue based on incomplete records, and we are unable to comment further based on open litigation regarding these cases." Lie, deflect, and lie some more has been a winning strategy for CBP since 2018. They are lawless and proving to be accountable to no one. As we've mentioned to the various oversight groups we've spoken to, Senator, CBP is the equivalent of a multi-billion-dollar corporation. They have their own press corps, and they can make statements to the press regardless of how dishonest or untruthful they are. And they're given the benefit of the doubt that the average citizen would not believe that an agency would openly make a public statement that was so patently untrue. As you are aware, and your staff called CBP out on this factual and known misstatement, they continue to do so and operate in all these facets with impunity.
Could rapid DNA technology be employed across our entire southern and northern border? And then in conjunction with the $100 you talked about cost, do do you have any idea what it would cost on an annual basis?
Senator, I don't have the annual numbers, but you could basically project what are the candidate pool in terms of the encounters, the 2 million plus folks that are being encountered along the border, and you could extrapolate based on the $100 test cost. What would it look like? We could deploy it across the entire southern border. You could do it in phases, depending on what the budget allows. You could have a mobile capability that allows you to take a group of machines or instruments to where there are high flow areas, and you can augment, you can shift, you can be very agile in your response with the rapid DNA technology. So it doesn't have to be deployed everywhere at once, but you could strategically deploy that capability at or near the border in order to get the immediate results that we need before we release these folks within 72 hours.
Thank you for that. There was a follow-up that I wanted to do with this would be for each of you three people, and I think I know the answer, but I want to hear it from you, and it's probably just a yes or no answer. Your treatment as whistleblowers, in your opinion, has Senator Mayorkas failed to comply with the whistleblower protection laws? Mr. Wynn.
Yes, Senator, I believe he has. He has either ignored the whistleblower protection laws or his staff has shielded him from any unpleasant facts about CBP's retaliation. So that suggests an unacceptable level of either malice or dysfunction.
Mr. Taylor?
Senator, I would have to agree with that. We do know that the current Inspector General for DHS has been aware of this for, we believe, at least 5 years. We've reached out no less than a half dozen opportunities, or I'm sorry, no less than a half dozen times to him. And through the work of your staff, your committee, if you go and Google CBP DNA whistleblower, I believe that we own the first 4 or 5 pages of results. We're recently on the front page of Government Executive. This is not a secret, what's going on with us or what's going on at CBP.
And Mr. Jones?
In short, yes, sir, I do believe that the Secretary has not protected us and followed through on the Whistleblower Protection Act.
Have each of you continued to be retaliated on beyond what I said in my opening statement?
Senator, at approximately the end of 2018, I reached the limits of my ability to tolerate being iced, and I sought a separate position within Customs and Border Protection. So I can say that the retaliation against me has ceased. However, I am on a drastically different career path than I would have been.
Senator, since the removal of my law enforcement retirement, my firearm, my law enforcement credentials, the position description change, short of terminating me, there's no basically more reprisal that can be done. Just by the change of my status as a non-law enforcement officer employee has likely precluded me from participating in some of the committees and groups that we have because you're required to be a sworn law enforcement officer. So again, was there any retaliation as of recently? Again, the only further steps that could take with me besides sticking me in a broom closet or terminating me have already been done. Thank you.
Senator Grassley, I was demoted 3 levels. My career progression was removed. My reason for leaving the FBI was to come to Customs and Border Protection to help them build a counter weapons of mass destruction program. That vocation was clearly taken from me. As Mike stated, my firearm, my authorities, my credentials also stripped from me. It was in one act, the final, I'll call it coup de grace of my position and career within CBP. Looking into the future, I have no place to go. We have been with 6 years with no valid employee appraisals. We get NAs for all of our categories. So even attempting to go within government, we're being retaliated against because we can't go anywhere because any agency will ask for your last employee appraisal as a gauge on whether you are a acceptable employee or not. So it does continue. I had someone recently say to me that they equated our existence to career terrorism, where we don't know what CBP is going to do to us next. And as Mike said, short of actual termination, we've been about as diminished as we can be and sit idle today.
Is it fair for me to assume for each of you three whistleblowers that there's never been any corrective action taken against the officials who engaged in this retaliation against you? Mr. Wynn,
Senator, that's correct. We are not aware of any such action that's been taken.
Mr. Taylor?
Senator Grassley, to the contrary, out of these individuals, minus the two that have been retired, are no longer with the agency. One individual was promoted to the senior executive service. Another individual was promoted to the position of assistant commissioner. The third manager was temporarily promoted to an acting deputy executive director position. Other individuals, as Mr. Wynn had mentioned earlier, have been permitted to retire or lateral to other offices or other DHS components with no encumbrances, despite the Office of Special Counsel highlighting many of these individuals' specific acts of retaliation. They were not investigated. None of them have been investigated. When you're under investigation, you have what's called a red book, and that allegation must be either substantiated or cleared before normally, under normal circumstances, you're allowed to leave a position or go to another office. Because these people have not been investigated in any way, shape, or form, they're allowed to move about freely on their own career path or wherever they choose.
And Mr. Jones?
Yes, sir, Senator Grassley. It should not go unrecognized that from the outset, our CBP leadership has had little interest in addressing any of the malfeasance. With respect to the failures of the agency leadership implementing the DNA Fingerprint Act law, the obstruction of the pilot, or those who have continued to actually retaliate against us. The CBP Office of Professional Responsibility was initially tasked by OSC to investigate our disclosure. At the conclusion of the OSC investigation, the special counsel stated in his letter to the president and oversight bodies on August 21st, 2019, I write this letter to inform both the president and congressional oversight committees of this misconduct, and it is my hope that further action can be taken to bring CBP into compliance with the law. I strongly urge Congress to continue its robust oversight efforts in this area, with a particular focus on accountability for DHS and CBP officials who have known for years that this situation existed, but chose not to act. I note that a number of CBP officials central to the agency's inaction were identified by the whistleblowers, but never interviewed in the investigation because CBP dismissed the extent of their involvement. The only ones so far that have been in any way punished has been us.